Schrödinger, as upset as Einstein about the implications of quantum theory, tried to show the absurdity of those implications by imagining such an experiment set up in a closed room or box, which also contains a live cat and a vial of poison. So arranged that if the radioactive decay does occur, then the poison container is broken and the cat dies. In the everyday world, there is a 50-50 chance that the cat will be killed. And without looking inside the box, we can say quite happily that the cat inside is either dead or alive. But now we encounter the strangeness of the quantum world. According to the theory, neither of the two possibilities open to the radioactive material and therefore to the cat has any reality unless it is observed. The atomic decay has neither happened nor not happened. The cat has neither been killed nor not killed until we look inside the box to see what has happened. Theorists who accept the pure version of quantum mechanics say that the cat exists in some indeterminate state, neither dead nor alive, until an observer looks into the box to see how things are getting on. Nothing is real unless it is observed. Well, that, of course, is the story of Schrödinger's cat that probably all of you have heard before. Well, a version of Schrödinger's cat took place in the 10th Circuit last week about whether the Bivens doctrine, which we have talked about many times before on the show, is either alive or dead, or perhaps both at the same time. We'll discuss that and another case from the 10th Circuit today on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Tuesday, May 14th, 2024. And this is a journey into the wild world of the 10th Circuit, the wild west of constitutional law. Actually, it's just in the west, maybe not so wild, a little wild this week, though. And joining me on this adventure into the Highlands as we put on our cowboy hats and drop off our city slickers and head for the hills is my colleague at IJ, Bob Belden. So, Bob, welcome back to Short Circuit.
Anthony, thank you for having me. You know, the Schrodinger's cat reading at the beginning reminds me of being at home, and parents of toddlers and young children know when you hear the sound of something fall in another room and possibly break until you go in the other room. You can imagine it was something of low value that doesn't matter to you. And it's not until you go in and you see it's something you like that's broken. So it's
broken and not broken at the same time.
That's right. It's a timely story.
It sounds like you speak from experience.
Not a significant amount of experience, but accumulating every day.
So we were talking before the show, you do not have a significant amount of time practicing in the 10th Circuit, which we're discussing today, but a little bit. I actually have zero experience, I think, practicing in the 10th Circuit. So the 10th Circuit, for those who don't follow the minutia of the Federal Courts of Appeals, it's kind of like the mountain states that they had to do something with after they created the massive 9th Circuit, which everyone agrees is way too big, even without California. And it has, so it's centered in Denver and Colorado, where the Court of Appeals, main Court of Appeals is, which we've talked about in the show before, beautiful library courtroom. And then it has Wyoming, which extends a tiny bit into Idaho and Montana through Yellowstone National Park, and Utah, New Mexico, Kansas, and Oklahoma. So this is your rugged individualists, pull yourself up by your bootstraps type of place.
Did you say it goes into Idaho?
Well, this is a tangent that I've been on. Listeners probably are like, oh, there he goes again with Yellowstone National Park. So, yes, but for those who haven't heard, Yellowstone National Park, if you ever looked at a map of Wyoming, you probably notice it goes a little bit into Idaho and Montana. So the federal district of Wyoming is the only district in the country that is in multiple states because it overlaps with Yellowstone. Because of course, in Yellowstone National Park, there's really no state authority. It's all federal. Like if you commit a crime in the national park, you're going to be prosecuted by the feds, even if it's for some ticky-tack thing. So that extends into Idaho and Montana. Why that gets interesting is because of this, one of my favorite law review articles ever by Professor Brian Kalt, which is that there are constitutional implications to your right to a jury trial under the Vicinage Clause of the Sixth Amendment if you commit the crime in those tiny bits of Idaho or Montana, because Montana, there's not a lot of people live there. There's some, but not. Idaho, there are 0 people. So if you have to be tried in the state and district, as the Sixth Amendment says, the government might have problems because there's no jury pool to
as long as you're
together.
in the Idaho part,
right? So the idea has always been, since Professor Kalt's article came out like 20 years ago, you could just go there and like manufacture cocaine and shoot off, automatic weapons or whatever, and you'd be fine. Commit murders.
Libertarian paradise.
There's a novel based on that came out a few years ago that I've been told is pretty good. So people
do you know what it's called?
Oh man, you're gonna tell. I'll do a little live research.
We can put it in the show notes.
Yeah. Well, I'll mention it in a minute. I know people at IJ have told me they've read it, and it's a good read. So luckily fictional. But we're going to talk about some non-fictional things, and I was saying it's a little bit of people pulling themselves up by their bootstraps, because a couple people there, it seems like their constitutional rights were not taken seriously, and that includes your case, which has to do with some Fourth Amendment stuff and a guy in a parking lot.
Yeah. So my case today from the 10th Circuit is called USA versus Daniels, and it comes to us out of the District of Colorado. So the underlying facts are all in Aurora, Colorado, which I think is just outside of Denver. So not quite the Wild West, but you can go camping on the weekend if you'd like. So this is a case kind of about 2 things. The first is the interpretation of reasonable suspicion to conduct a Terry stop in a kind of post-Bruin world, if you can think about the way we look at the Second Amendment now under Bruin. And it's a case about a suppression hearing and suppression motions at a criminal trial. So reasonable suspicion, just at kind of like a high level under Terry is...
and if you could explain Terry maybe for the non-lawyers out there.
Yeah, I mean, it's a Supreme Court case from, I think, like 1968 that says basically cops can make a brief investigative stop if they have reasonable suspicion that criminal activity is afoot. And
so that can be lower than they need for an arrest, but it's not an arrest, so they just need a little bit. But it can't be nothing.
Right. It's sort of a sliding scale, like any American is totally within their rights to just refuse to speak to police when they ask to talk to them. But the police are equally within their rights, if they have reasonable suspicion of criminal activity, to kind of stop a citizen and say, what's your name, that kind of thing. And there's a sort of sliding scale. As the kind of detention gets started, it has to be justified at its outset. And as it continues, the cop has to have reasonable suspicion to continue detaining the person. So that is kind of in a broad sense what reasonable suspicion is. It's much lower. You mentioned making an arrest, Anthony. It's much lower than like probable cause or, beyond a reasonable doubt, any of those other standards that listeners are probably familiar with. But it's an objective standard, and it's supposed to be based on sort of the facts and circumstances that present to the law enforcement officer when they start and carry on the detention. The second thing that this case is about is a suppression motion. So when you're tried in a criminal case, you can make a motion to suppress certain evidence that the government wants to introduce against you, and you have to show. I guess you can move to suppress on a number of different grounds, but one that's quite common in a criminal trial is to say this evidence is something called fruit of the poisonous tree, which is the concept that when law enforcement or the police violate a constitutional right of yours, to get access to information. Typically, it's going to be the Fourth Amendment, but I think that there are some other amendments that have kind of a fruit of the poisonous tree doctrine that follow. But um, if law enforcement gets evidence as a result of a Fourth Amendment violation, you can kind of think of an actual tree with branches growing off, and subject to some exceptions, any evidence that the law enforcement officers obtain after they violate someone's rights, someone's Fourth Amendment's rights, is called a fruit of the poisonous tree and can't be used at a criminal trial. So to kind of tie those two concepts together, this U.S. versus Daniels is a case where a criminal defendant moves to suppress certain evidence at his criminal trial, and he actually succeeds because law enforcement used something or planned to use something in the investigation that was based on a fruit of the poisonous tree, which is a violation of the reasonable suspicion rule. So that's kind of what this case is about. Now, the facts are relatively simple. If you can sort of remember back to the last time that the Kansas City Chiefs played the Tampa Bay Buccaneers in an enormous game.
Yeah, I think that was the Tom Brady Super Bowl after the Patriots. That was like, his GOAT moment, right?
That's right. And, one is left with the very firm sense after reading the majority opinion that Judge Seymour is a Broncos fan. Because there is a footnote recording the score from the game and, just reminding everybody that the Buccaneers won. But this is February 7th, 2021. It's a little bit before midnight, and the Aurora police get a 911 call. And it's not an emergency. It's just somebody who lives next to this building calling in to say, I see three guys in this parking lot, and they have guns, and they're taking these guns in and out of their pockets, and they're standing by a black SUV. And I think the quote that the majority uses over and over again is that the caller said, "It looks like these guys were about to do something." Doesn't say what, doesn't say it's an emergency, doesn't say, something's really about to happen. The cops put a note down and say, we'll send somebody out to take a look. So two officers come out to the parking lot, and when they get there, they see what is a pretty well-lit, busy parking lot with cars coming and going, and they see two dark SUVs. So the 911 caller said the guys with the guns were like standing around a black SUV. Cops get to the parking lot, see two black SUVs, but they don't see the three men that the 911 caller had described. The caller said there are three black guys here with black hooded sweatshirts on, and they've got, guns, and they're taking them in and out of their pockets. Well, the cops get there, and they don't see guys in black hoodies, walking around a black SUV. What they do see is Mr. Daniels, who I'm going to go out on a limb and say that Mr. Daniels is also a Broncos fan based on his attire, which is described in the opinion. The majority notes that when the cops get there, Mr. Daniels is in fact standing next to a black SUV, but he's wearing an orange jumpsuit and an orange shirt with a reflective stripe on it. So he's, bringing attention to himself, and maybe the kind of thing you would expect a 911 caller to mention if they suspected somebody in a bright orange jumpsuit of engaging in criminal activity. But the cops see Mr. Daniels, see that he's got this outfit on, but he is standing next to a dark SUV. So the cops start to approach. As they're approaching, Mr. Daniels says something to the folks in the SUV, which the officers cannot hear. They cannot hear what is exchanged between Daniels and the SUV occupants. But as soon as Daniels says something, the SUV pulls off. And it's important to note that, the SUV pulled off in exactly the same manner that other cars had been sort of idling into the parking lot, pulling out, driving away. There had been a lot of activity in the parking lot. And so aside from the SUV leaving, when Mr. Daniels said something. Nothing really unusual about the SUV taking off. But after the SUV leaves, Officer Idler, this is where this is sort of the initiation of what we talked about, the Terry stop. Officer Idler, one of the police officers, makes contact with Mr. Daniels and says, they refer kind of vaguely to Daniels complying with the orders. It's not exactly clear what Idler, the officer, said when he walked up, but it's clear that Daniels complied with kind of an order to stand there, and Daniels provided his name to the officer. Now, from there, they kind of don't do much at the parking lot, but other officers follow the SUV, ultimately stop it, and find I can't remember if they find like multiple guns or multiple drugs or something, but they find a Glock in the back seat and find out that it's been stolen. And
the stop was appropriate, right? Because it ran a red light or something like that.
Yeah, that's right. Yeah. The SUV drove legally for a little while, ran a red light, gets pulled over, and is getting searched. So using Daniels's name, the cops back at the parking lot run a background check on Daniels, find out that he is a prior felon. They don't say what he did or what he was convicted of, but the police then use his name, Daniels' name, to get a warrant for his DNA. So what they want to do is, we have his name, we use the name to find out he's a felon. We want to use his name now and the fact that he's a felon to get his DNA, because we want to show you his DNA is on this Glock in the car. Because, as most people know, if you read a criminal law opinion in the United States from a federal court, you almost always see a charge against somebody for being a felon in possession of a gun, because that's an easy crime to prove. It's sort of not quite a status crime, but it's very close. Once you're a felon and you have a gun, you've committed this crime, and there's a lot of punishment for it.
Yeah, as we've said in the show many times, there are a lot of times you think, why wasn't this prosecuted in state court for like a real crime, and instead it's in federal court for a felon happening to have a gun, and it's because it's a heck of a lot easier.
Yeah. So, the grand jury indicts Daniels on like a very simple charge of being a felon in possession, and I am not sure. I'm not sure if he was represented at the trial court level by the federal public defender, but he's represented on appeal by the federal public defender. And, I just would say, like, kudos to them for raising this argument. I mean, I think it's a well argued Fourth Amendment case. And you can see from the sort of procedural record that is described in the opinion that the trial court bought into all of the arguments that Daniels was making. He moved to suppress the DNA evidence that the government collected, showing he had actually been, maybe not in possession, but he had been in contact with that stolen Glock. So
I guess that's close enough for, quote, possession under the law that you touched it.
Yeah, I mean, if you're on this side of the V, I think it's enough for possession. So the cops, the prosecutors charge Daniels felon in possession. He moves to suppress the DNA evidence and actually wins at the trial court level. And the trial court's explanation is, you had the police, Aurora police had a 911 call that was semi-anonymous. Like, the person called in, didn't give their name, didn't know the people in the parking lot, but they were able to provide some detail about like the area, what was going on. They were contemporaneously viewing it. So it wasn't like somebody called the police and told them, John Doe did this 2 weeks ago in this location. There was some sort of active corroboration. So that doesn't make the tip really super reliable or unreliable. This is kind of a totality of the circumstances analysis. And the judge at the trial court level thinks, the cop showed up and didn't see the guys who were mentioned in the complaint. You show up and this guy complies with your order as soon as you come up, and you don't even know what he said to the person in the SUV. Trial court is convinced there's not enough evidence of suspicion of criminal activity at the outset of the encounter and suppresses the DNA evidence on that basis. So the government appeals, and it is not as interesting really to run through the majority opinion, because what the majority opinion does is look at the sort of facts that were presented to the trial court, particularly the 911 call and the details that were covered there, then the kind of time and location. Judge Seymour's like, it's the Super Bowl and the Chiefs lost like a bunch, by a bunch. So, of course, there are good people here near Denver out celebrating the fact that the Broncos didn't have to watch the Chiefs win. No surprise there. And then the SUV, sort of how it reacted. You can really, in this situation where you're looking at things with the hindsight of 2020, and you're like, oh, the cops come up and they eventually stop this SUV and they find the gun in it, and that this guy had the gun, or he at least touched it and he shouldn't have. So you're seeing all these facts, and after you've read and know how this case ends, that somebody may have been committing a crime here. So you read these facts and infer that maybe something bad is happening. But it's the trial court and the majority, I think, are very good about at least the SUV's behavior. Like, this is totally consistent with, you just being out front of your house, which this Mr. Daniels was. The police come up and you see the police coming, and who knows what your relationship or your past or your history with the police are. Who knows who's in the SUV? Maybe Daniels's, family members are in the SUV, and he's like, well, we don't need any unnecessary interaction with police officers. Why don't you guys take off? I'll see what happens. That's not illegal activity. Very plausibly did Mr. Daniels lean in the window and say, hey, guys, the cops are coming, move the dope. That could have happened, but it's equally plausible that it didn't. And so I think that the majority opinion really gives credence to the fact here that if we're ignorant about whether something is criminal activity or not, we have to give the tie to the citizen who is ostensibly minding his own business when he's interacted with when the police interact with him. So the majority goes through those facts and analyzes the totality of the circumstances. And, one particularly interesting thing in discussing the 911 call, the majority opinion talks about the Supreme Court's decision from 2022 in Bruin that recognized the Second Amendment right to bear arms sort of outside of the home, kind of recognized that Heller is not the outer limit of the Second Amendment right. But Bruin also sort of, I don't know if it shifted or formalized the constitutional analysis from Heller, where if, your conduct is covered by the text of the Second Amendment, then the government has to look to, text, history, tradition, those kinds of things to try to justify the limitation. The majority says we've got three guys here who have firearms in their pockets, and under Bruin, that seems like totally lawful activity. It's not clear that can be evidence of or a basis for reasonable suspicion of criminal activity. I think that is kind of the most interesting part of the majority's analysis, that kind of preview of the work that Bruin is doing in these cases. But I think that Judge Ide files a concurring opinion. She concurs in the judgment, and it seems her main sticking point with the majority is exactly this point about the 911 call, that there is a lot more nuance to how you analyze a situation under Bruin and sort of the tradition and historical context of regulating firearms. She points out that local governments are authorized to regulate firearms. Private property owners are allowed to regulate who can carry a firearm. And so she takes issue with the majority opinion at a high level, looking at a group of guys like, hey, I've got my gun here. I've got this gun. Maybe that's lawful activity, but it's not the craziest thing to say somebody, taking a gun in and out of his pocket could be evidence of, could signal that criminal activity is afoot. And so she Judge Ide would rely on the much more concrete factor that the 911 call did not identify Mr. Daniels, the guy who wound up being arrested, and only identified a black SUV or a dark SUV. And when the cops showed up, there were two. And so one of the fundamental things about reasonable suspicion is that it has to attach to the target of your suspicion. Like, it has to attach to an individual. And so, you can't show up and say, it looks like there's criminal activity afoot. I'm going to start arresting people or detaining them until I find out what's going on. So at the end of the day, the 10th Circuit affirms the trial court's suppression. And I am not sure what happened to Mr. Daniels, but I would imagine it was much more difficult to prove. He was a felon in possession of a firearm if they couldn't use his name at all.
Yeah. And then you couldn't use his DNA, and that's all they had. I mean, we don't know what happened from this opinion to the folks who were in the SUV, what other evidence was there, what, if they were prosecuted. Could be a lot of things.
Yeah, I was kind of surprised. I remembered the sort of all of the exceptions to the fruit of the poisonous tree, like inevitability or that kind of thing, like we're going to find it anyway, or other sources. I was surprised they didn't have another source for this guy's name, but I guess the way the record shook out. What
I was left with from this opinion is, I don't even know if maybe it's in the record that it was, but I don't even know if this SUV was the one the 911 caller saw, because they said that, like, it seems like it was, as they said, a high crime area, which can mean a lot of things, but they also said it's one of these big apartment buildings with a big parking lot, and the parking lot was completely full.
Mm-hmm.
So it's not, an abandoned kind of area. There's a lot of people out there because the Super Bowl was earlier that day. People were kind of up and milling around, even though it was late.
Yeah.
And there could have been other SUVs coming and going that were black.
Totally.
This guy had an orange jumpsuit. There was no orange jumpsuit on the call, which you'd think would be noticed. So
I think that's the biggest red or orange flag. One of those. Is bad.
I was kind of in between, I guess, the two opinions, like maybe you are, and that I think the concurrence does have a point that just because people are exercising their Second Amendment rights doesn't mean it can't be raise a red flag about something going on. Like, if you saw, it's legal to have ski masks, knives, and rope. But if you see a group of guys getting in an SUV, maybe they're not even wearing their ski masks, but they're holding them. It's in the summer. They have rope. They're wearing all black, and they have some knives. That's probably not, Boy Scout activity.
Right.
And so I might call the cops if I see that, even though everything is at that point perfectly legal. The one thing it seems like the police just were doing their kind of over the top police thing here is when they get there, they immediately, before they even talk to the defendant, they tell him hands up. And then they come and do their Terry stop instead of just going up to him and saying, "Oh, hi, how are you? What's your name?"
Yeah.
Or whatever. Maybe he would have talked to them.
Hey, excuse me, sir. Have you seen three guys pulling guns out of their pockets and putting them back in their pockets?
Oh, do you live here? What's, us Fourth Amendment lawyers would probably know enough to not tell what your name is. But a lot of people would. This guy might. And then all of this would have been fine if they hadn't, just gone over the top. Guns blazing, but not guns blazing from the outset. Yeah. So, by the way, I looked up while you're talking about the case, and the name of that novel is Free Fire, written by C.J. Box, and it's I haven't read him, but it's part of the Joe Pickett series.
Okay,
which I know some people are into. Detective.
Is it like novels. A utopia or a dystopian situation in the?
Oh, I think it's just a murder in the park.
Oh, okay.
Yeah. Okay. So anyway, people can learn a little bit about that. Check it out. And the law review article I love so much is the perfect crime.
The perfect crime.
We'll put links in the show notes to all that. So that is our first adventure in the 10th Circuit. Now we're going to have another one where we're going to go to prison. federal prison. And it actually, the backstory on this is quite interesting, but it's not really relevant to the case at all. And that's that the defendant, his name, well, I'm sorry, the plaintiff. So this is a civil case. That the plaintiff is, I'm going to get his name wrong, but Kaufan Kamis Mohamed, but we'll call him Mr. Mohamed. So he was convicted for the bombings of the U.S. embassies in East Africa in 1998 that some of our older listeners may remember. It was, of course, a precursor to 9/11. It was an Al-Qaeda job. He was then arrested a year later in South Africa and immediately deported to the U.S. So he's been in federal custody since 1999. And he was convicted and sentenced to life without parole. So he is a lifer in federal prison. All right. So it sounds like he's making his life in federal prison. Now, he, as you might imagine, for someone in his state and maybe even, someone, I don't know if he's reformed or not in prison, but very likely he hasn't. He still believes his Al-Qaeda beliefs, but he has been in previous litigation about his prison conditions. So this case is not exactly anything new. And he alleges that he was mistreated in prison, and so he's filed a lawsuit to try to get damages, essentially, for what has happened. I should go back and say I'll bring up the whole Schrodinger's cat hook in a moment, but the reading at the beginning, I should be fair, was from a kind of older book from the 80s, physics book called In Search of Schrodinger's Cat, Quantum Physics and Reality by John Gribben. Of course, people love to talk about Schrodinger's cat, and people get it wrong often. Not exactly parallel to this situation, but the whole dead and not dead is very relevant. And the dead and not dead is luckily not about the prisoner here, but about this doctrine called Bivens that we've talked about many times on the show, which is a case from named after a case from 1971 at the Supreme Court, where the Supreme Court essentially created a cause of action. So that means a way to sue for damages against federal officials. So not state or local officials. There's actually a statute, Section 1983, that does that. But for federal officials, there was no statute generally. And so the court created this cause of action called Bivens, and it was been extended in a couple different cases, including one called Carson, that had to do with prison officials withholding medical treatment. Okay, that'll be relevant in a minute. All right, so let's get to the facts. So Mr. Mohamed, he is on hunger strike. Why? We're not told. It could be all kinds of things. So he's on hunger strike. They take him out of his cell. We don't get a lot more facts than that. And then as they're taking him back, these prison guards beat him up. And I should say this is at the motion to dismiss stage. So all of these facts are ones he and his lawyers put together in their complaint, and we accept as true for purposes of this stage of the case. But, I'm sure the prison guards have their own side of the story, but this is from his complaint. So he says they beat me up, and then these other people, including a physician's assistant, don't intervene to stop it. Then a nurse comes and looks at my injuries and doesn't help me. Maybe assess it. I was pretty beat up, but assesses that, but doesn't try to treat the injuries. And then another nurse and the physician's assistant later are involved in treating some of them, but not all of them. They don't help me very much. And I was unjustly beaten up in the first place. And so all of this is just really bad, and I should get damages for it. Also, they said, thousands of pages of documents that he's written over 20 years of being incarcerated. And he had some books and some other materials, and they were taken from him, and only some of them have been given back. So then he had post-traumatic stress from losing this stuff. So that's the allegations. Okay. Then he sues. And he says, under Bivens, I have a cause of action against these various officials, including the physician's assistant and the nurses who just didn't treat me. So the lack of medical treatment for injuries in prison is relevant to this old case, Carson, that said you have a cause of action when federal officials fail to give you medical treatment. That's an Eighth Amendment violation. The government, he also brings some claims under the Federal Tort Claims Act. It's not really an issue in this case, but it's kind of in the background. So that's this act that says for regular claims, so like tort claims against federal officials, you can't bring those claims against the officials, but you can bring it against the United States itself. So it's kind of a way of shifting the cost to the government. And those are still live down below. That some of them get thrown out, but not all of them, and they're not at issue on the appeal. But so the district court says, all right, yeah, it looks like at least some of these Eighth Amendment claims you have under Bivens, we'll let them go forward. Okay, so motion to dismiss, denied on those claims. Now, normally in a normal lawsuit, you would then go forward in those claims. You would have discovery. The government would get another bite at the apple at summary judgment. However, we talked many, many times on this show about qualified immunity. So qualified immunity is you say, well, maybe that was unconstitutional, but it wasn't so unconstitutional that it was clearly established. And therefore,
meaning clearly established, meaning somebody did exactly what you did at the exact same time to the exact same person on the exact same day.
That is as it's usually framed by the government and some courts, yes. So there's all kinds of ways to frame it, of course, but basically it wasn't so unconstitutional, so obviously unconstitutional that you win. Now, qualified immunity, you can appeal straight away if you're a government official. So whether it's a state, local, or federal official, in fact, qualified immunity came out of a federal case against President Nixon and some aides. You can make that argument. And you can appeal it immediately. So you can appeal the motion to dismiss stage. You can appeal again at the summary judgment stage where you don't actually go to trial, but you have evidence, and you can appeal after trial even with qualified immunity. But then, of course, you could appeal anyway. Well, this is motion to dismiss, and they appeal. But you know what? I don't know why they did this. This is like lightning in a bottle. Maybe because the facts are just so bad. I don't know. But the lawyers do not use qualified immunity on the appeal. Whatever claims they had before they drop them. For these particular claims that survived, that they appeal up, the Bivens claims, they don't say qualified immunity. All they say is there's no Bivens cause of action here. Now, I can see maybe why they did that. And they did that because Bivens is on life support. Or maybe it's dead. That's where Schrodinger's cat comes in. Bivens has been kneecapped many times over the years by the Supreme Court. Basically, the early Burger Court in the 70s thought Bivens was a thing, and they kind of came up with a few ways to do Bivens. And since then, the Rehnquist and Roberts courts have just kept beating it. Every year, it seems, we get a new beatdown on Bivens. And we wouldn't have done Bivens today. We think that was terrible. Congress should come up with a cause of action. Courts shouldn't be doing that. I've explained ad infinitum, and also of my colleagues like Anya and Patrick, why that's not true. But whatever. The court has said that. And so Bivens, if it exists at all today, is super narrow. And really just those three areas. Bivens itself was a Fourth Amendment case. Carson was this Eighth Amendment case, and then there's another case about sex discrimination under the Fifth Amendment. That's it. That's all that's left of Bivens, that if anything. So the officials say on their appeal, the prison guards and the medics, they say, look, Bivens is dead. There's no Bivens anymore. And so we can appeal it right away. How can they do that? All right. This is something we haven't talked about too much on the show. I will do real quick because we could spend hours on it. The collateral order doctrine. That sounds pretty sexy, right? Collateral order doctrine. No, of course, yeah, Bob is nodding right along. Well, usually when you make an appeal, the case has to be done. Final judgment. Everything except ancillary stuff like maybe costs and attorney's fees or enforcing a judgment. So that's a normal course of business. But you can appeal earlier in certain there's certain ways you can appeal. Like if you have you ask for a preliminary injunction and that's denied, you can appeal that. So that's its all other thing. You can also appeal if you think it's a really important issue that is going to affect the life of the case, and if you appeal at the end, it's kind of too late. So you want to do it early. You can have the district court certify the question. This happens sometimes. For whatever reason, that didn't happen here. Because the district court's saying there's a cause of action here, you could say, given that Bivens may or may not be dead, could be something you could appeal. But that doesn't happen. And so the government appeals and says, well, this is under the collateral order doctrine. So the collateral order doctrine is really judge-made exceptions to that finality rule. It comes from this case called Cohen from 1949. There's this balancing three-part test that I don't think we need to get into. The opinion is most of just going through all the rudiments of this test. But essentially, it's something that would stop everything right away. That's super important, and that you can't really adjudicate later in the case. So that's why qualified immunity is like the classic, whether you think it should apply or not. This is what the courts have said. Qualified immunity is like that because it's really an immunity from litigation, not exactly immunity from liability. So if I'm supposed to be immune from, going through discovery, sitting for depositions, having to go to trial. So you're a police officer and you're saying, I shouldn't have to do all that because I have qualified immunity. Well, then the reasoning is, well, you should get that taken away right away and then go to a court of appeals because it's that important. But courts have said over the years that you can't come up with collateral order doctrine worthy issues willy-nilly. So they're pretty circumscribed. And the Supreme Court hasn't come up with one in a long time. Now, the Supreme Court in dicta has kind of talked about what are the limits of this in different places. And there's a case from 2007 where there's some pretty heavy dicta that says this doesn't apply to Bivens cases. So if a court says Bivens applies, you can go forward with the case and you think, oh, wait a minute, we could stop the whole case right now if Bivens doesn't apply. That's not enough, is what this dicta says. Now, a couple other circuits have said that yes, you can't appeal. So I agree with Mr. Mohamed here. You can't appeal denial of Bivens if you're a government official. However, a dissent in one of those cases in the Third Circuit, Judge Hardiman, and both cases are fairly recent. I was a little surprised by that. Judge Hardiman says that was drive-by dicta by the Supreme Court. And so really we shouldn't treat it that seriously. And dicta, of course, is what his court says when it's not a holding, it's not the actual ruling of the case, but it's other stuff that the court says. And the 10th Circuit says we take Supreme Court dicta pretty seriously, maybe more seriously than the Third Circuit does. And so we can't overlook this, even if Bivens has kind of become less of a thing since this case in 2007. And so the bottom line for the majority is, to cut a very long story short, that there is not a reason to appeal a Bivens denial here, denial of the I should say Bivens, saying that Bivens is a cause of action, that there is one here. That's not a reason for an appeal. And they also say, you read between the lines, it's kind of like, you guys could have raised qualified immunity, and then you get to talk about Bivens also in the appeal, because that's the hook. And then everything else kind of goes up with it. They said, well, that could be true, but you didn't even try that here. I think that's the reason, by the way, there's not a lot of other cases on this. There's just these two other recent ones, is that everyone always also does qualified immunity if you're in the Bivens zone. I mean, why? If you're a defense attorney, like, why wouldn't you? But they didn't. So,
I mean, the only thing
I can speculation, think of, Bob, why they didn't.
I have some speculation. Maybe it's a little bit of a heat check by the feds here, right? Like, you point out how much the ground has just totally gone from underneath.
Like, this is the
Bivens.
test case. They're purposely doing it.
Like, oh, well, we've got this guy who's been in federal custody for 20 plus years, probably not the most sympathetic person to be bringing this claim. You're right, it's at a 12B6 stage where we're supposed to take things as true because they're averred in a complaint, but maybe a court is going to look at it a little bit sideways, and now is as good a time as ever to only raise Bivens on an interlocutory appeal. And if they really want to kill it, they'll find a way to reach it for us. And I mean, maybe that's what's going on. Maybe it was a mistake, no idea. But if you want to guess, like strategic, sinister speculation, that's what I would offer.
Having brought some test cases myself, I think that very well could be what's going on. Test cases with more sympathetic clients, but I see where they are on the other side. The dissent, Judge Timkovich, he says, and this is what I find actually most interesting in the opinion. He says, look, Bivens is dead. And he does not talk about Schrodinger's cat. He talks about Jacob Marley and quotes from the Christmas Carol about how Marley was dead as a doornail and everyone knew it. Marley was dead to begin with. There is no doubt whatever about that. That's the quote he has. I guess he doesn't do the doornail part. So he says, look, even if you have facts just like Carson or just like Bivens, maybe your name is Webster Bivens, you're beaten up by narcotics agents in front of your family without knowing their names, which is the facts of Bivens, even then you don't have a cause of action. And so because there just is not a claim here, we can take the case on the collateral order doctrine. Now, I have to say, I don't think that's right. And this is just my limited understanding of the area, but this is a claim that you don't have a cause of action is a 12B6. And for non-lawyers out there, that's saying that even if what you allege is true, the law does not give you relief. And 12B6s happen all the time in all kinds of areas. Government officials, non-government officials, they're all over the place in state or in federal litigation, but the equivalent in state litigation. Just because you say you win, maybe if you won that way at the end, at whatever stage of the case, that someone doesn't have a cause of action, does not mean that it is equivalent to, say, qualified immunity. That it's so important that you can't let the case go on. The only argument there, majority kind of talks about that, is that, well, we're the government. We're government officials. We're so important. We can't subject ourselves to all this litigation and trial that we should be able to appeal right away. And that's not what the doctrine is. The doctrine is these limited areas within that world. And it's not just for government officials, but especially is. So just because you win that there's no cause of action doesn't mean you can appeal. And I'm a little confused, like, why he thinks that's true, and he gives his arguments in the dissent. But anyway, he doesn't win there. But I think the majority kind of leans on that there is still maybe a Bivens cause of action here. They don't exactly say, even if there wasn't, there would be an appeal here. Although kind of reading between the lines, maybe they are saying that. So that goes into lots of stuff we could talk about causes of action in the federal constitution. That is, we've talked about before, but that was my take on the dissent too.
Yeah. Well, I mean, I think at the end of the day, I think the majority has probably the right read of sort of the outcome. I mean, the purpose of Bivens, you think at a high level, the purpose of qualified immunity is helping a government defendant avoid litigation or the burden of litigation, right? Like, what is the purpose of Bivens? I mean, it's just from the outset, square one, totally a different purpose, allowing somebody to vindicate their rights under the Constitution. I mean, for purposes of an interlocutory appeal, you group things like qualified immunity and preliminary injunctions because there is this, really good argument that just the injury of going through the litigation is a harm. But, there is no suggestion of that in Bivens or the Supreme Court case, creating Bivens or recognizing Bivens. So I think it's appropriate to treat the two differently. I am surprised by, I would think that the quote that might be a little bit better for Bivens would be from The Princess Bride, Billy Crystal, only mostly dead, because, if the Supreme Court can recognize Bivens, it can recognize Bivens 2.0 when somebody convinces them to let a plaintiff bring a cause of action directly under a constitutional provision. So I don't know that it's dead all the way, but certainly on its way, it seems.
Yes, the question as to whether Bivens has anything left to it is an important one, but just because something's important doesn't mean you get to flout the normal rules of civil litigation. I think that's what these prison guards are trying to do here.
Yeah. Well, I think that our tour through the 10th Circuit has been a whirlwind.
Yeah, there's peaks and valleys, and the El Dorado's always over the next hill, and we'll keep searching for that. But I think we made some good discoveries, a few gold nuggets along the way here, Bob. Nice. So thanks for saddling up with me.
Yeah, it was a rocky ride.
Indeed. Well, I hope the rest of you enjoyed it, and until next time, I hope that all of you get engaged.